What's up, government class? Hope you guys are doing well. Before you change the channel, because I know that some of us, those of us that do watch these videos, maybe there's a tendency to turn them off early. So, just to give you a teaser, I have a special guest lecturer. Actually, it's an interview on Monday. I'm going to interview a lawyer who argued a case before the Georgia Supreme Court. And when he argued it, that year it was considered the most influential case, um, Supreme Court case, state Supreme Court case of the year. So uh, look forward to that and watch the lesson on Monday. Today we're going to talk about our court system, the judicial branch of Georgia. Just like we talked about the judicial branch, the federal judicial branch, right? We have that in the state as well. Under the 1983 Constitution of Georgia, the judicial power of the state is vested in 7 levels or classes of courts. The Georgia court system has 2 appellate level courts. When you see appellate, just think appeal. The Supreme Court of Georgia and the Court of Appeals of Georgia. When we say that appellate or Court of Appeals, that's where a decision or Supreme Court, at that point, a court decision has already been made and they're trying to get it changed. There are 5 classes of what we call trial level courts: superior, state, juvenile, probate, and magistrate. And then there are like 400, give or take, special courts that are local. So we're not going to memorize all 400 of those. And believe it or not, the end of the school year is coming up. So we got to move fairly fast. The most familiar trial court in Georgia's judicial branch is the Superior Court. Every county has to have at least one Superior Court or be part of a judicial circuit composed of several counties. They have general jurisdiction, and what that means is they hear almost any civil or criminal case. Civil cases, that's when it's about money. So like O.J. Simpson was acquitted. He was found not guilty in criminal court, but he was ruled against in civil court and had to pay a bunch of money. If the county's population warrants it, then the locality will have a magistrate court, a probate court, and where needed, a state court and a juvenile court. So let's take a look at Superior. The Superior Court is Georgia's general jurisdiction trial court. It has exclusive jurisdiction over trials in felony cases, divorce, equity, and cases pertaining to land disputes. Georgia counties are divided into 49 judicial circuits, each of which has at least one Superior Court judge, remember, or is part of a group of county, a judicial circuit made up of a group of counties. Sessions of courts must be held in each county at least twice a year. Superior Court judges are elected on a nonpartisan basis in circuit-wide elections for 4-year terms. Anytime I say nonpartisan, hopefully you guys roll your eyes at that. Because, and this is a little jaded, but it's really hard to come across something that's truly nonpartisan in the government. And federal and state, their state's just the same. Usually. Sometimes people do great stuff together by compromising. Superior Court judges elected on a nonpartisan basis. To qualify as a Superior Court judge, a candidate must have been at least 35 years old, be a citizen of Georgia for at least 3 years, and have practiced law for at least 7 years. State courts. It's confusing because you would think really all of these are state courts, but this specific type of court within the state court system, within our state's court system, is called, quote, state courts. In 70 counties in Georgia, state courts exercise jurisdiction over misdemeanor violations. That's things like traffic cases, and they adjudicate civil actions, except in cases which the Superior Court has exclusive jurisdiction. State courts are authorized to hold hearings on applications for an issuance of search and arrest warrants and to hold preliminary hearings. The judges at state court are elected. They serve 4 years at a time in countywide elections. Another thing that state courts can do is issue search warrants, search and arrest warrants. To be a judge on the state court, you have to be at least 25. You have to have been admitted to the law practice for at least 7 years, and you have to have lived in the state for 3 years. We already said that, didn't we? Of the 109 authorized state court judgeships, approximately one half of the positions are full time, and the others are part time. Part time judges can practice law except in their own courts. Probate court. Probate courts used to be called courts of ordinary. They have original jurisdiction on the probation of wills, administration of estates, so like homes and possessions, appointment of guardians, and involuntary hospitalization of mentally incapacitated adults. So probate courts handle a lot of important stuff. They also administer oaths of office and issue marriage licenses. They're also in charge of printing off ballots and counting votes. Certain counties, probate courts actually are the courts that handle traffic and school attendance laws. You guys don't need those laws because you're all very eager to come to class and learn. I love that about you. They can hold what they call habeas corpus hearings. I was actually just watching an episode of Law and Order where they were talking about that, or preside over criminal preliminary hearings. In counties with a population larger than 96,000, someone involved in a civil case can request jury trial in the probate court. So, probate judges handle certain misdemeanor cases, traffic cases, violations of state game and fish laws in counties where there's no state court. Right? So, again, these counties have courts, and they are courts of the state government, but they're not state courts. Each county has a probate court with one probate judge who's elected for 4 years, and different counties have different qualifications. In the larger counties, 96,000. It's not a big county really, but it's not tiny. They have to have practiced 7 years, 35. Same rules. In all counties, a candidate has to be at least 25, a high school graduate. See that, guys? There's a reason we're all doing this. You're all doing this. Courts with jury trials. Juvenile courts. The jurisdiction of juvenile courts extends to delinquent children under the age of 17 and deprived children under the age of 18. You guys, I'm sure, have watched enough of the news or kept up with the headlines. Just because you're under 18 does not mean you're going to be charged as a child on a lot of these more serious crimes, murders, and stuff. You'll see from time to time uh, kids will be charged as adults. They have concurrent jurisdiction, the juvenile courts do, with superior courts in cases involving capital felonies, custody and child support cases, and proceedings to terminate parental rights. They also have jurisdiction over traffic violations when it's a minor and other consent cases. So, wanting to enlist in the military if you're underage, or wanting to get married if you're too young. The superior court, remember we said concurrent? That means like going together. The superior court has jurisdiction over juveniles who commit certain violent felonies, including murder, voluntary manslaughter, rape, and other sexual offenses, and armed robbery if committed with a firearm. Juvenile court judges are appointed by the superior court judges. They serve 4 year terms, and we won't go through the stats on qualifications. Magistrate court. Justice of the peace courts and small claims courts are called magistrate courts. Their jurisdiction includes smaller civil claims, so $15,000 or less, dispossessory writs, county ordinance. You guys, I'm not going to lie. I don't know what dispossessory writs is. I'll look that up for you. County ordinance violations, certain frauds, etc. With magistrate courts, there's chief magistrate, and they're going to be the ones that assign cases, set the schedule, and that sort of thing. They're an elected official, so they're county positions. You know, chief magistrate, Glenn County. So the vast majority um, run for election, but you see, you got your bonus fact. There are a few, three or four, where the magistrate is actually an appointed position. Magistrates can grant bail. Some cases that would have to be done by a judge, but certain cases they grant bail. Appellate courts. Georgia Court of Appeals. The Court of Appeals was established by a constitutional amendment in 1906. Under the Constitution, the Georgia Constitution, it's a court of review and it exercises jurisdiction over appeals from lower courts, superior state, and juvenile courts in any case not reserved to the Supreme Court. And we're going to talk about the Supreme Court in a minute. Those include civil claims for damages, child custody, workers' comp, other administrative things, all criminal cases other than capital felonies. There's 15 judges. Chief judge serves for 2 years. And cases are heard by there's 15, but a panel of 3 is like the unit. Why can't I think of the word? The segment. You get like a 3-judge segment to hear a case. If the Court of Appeals can't come to a decision, that's when it goes to the Supreme Court. So some cases are designated for the Supreme Court, and some it goes there after it fails to get a decision in the appellate court. Court of Appeals judges elected for 6 years. The Supreme Court. An 1835 amendment to the Georgia Constitution of 1798 first authorized the Supreme Court. The court finally came into being in 1845 when the Georgia legislature established the state's first appellate court. It functions as a court of review and it exercises exclusive appellate jurisdiction in cases in which the constitutionality of a law, ordinance, or constitutional provision has been drawn into question, and in all cases of election contest. So the Supreme Court can see cases involving title to land, equity cases, wills, habeas corpus cases, cases involving extraordinary remedies, divorce or alimony, just all of these things here. It can be appealed to the Supreme Court. It serves in terms in there in January, April, and September. Cases are assigned in a rotation to the justices for preparation of opinions and decisions of the whole court. When a justice prepares an opinion, it is circulated for study to all of the other justices, and after discussion in blanc, they call full court, the opinion is adopted or rejected by a majority of the justices. The 9 justices who serve on the Supreme Court are elected to 6-year terms in statewide nonpartisan elections. Again, most of this information I got off of our state website, our .gov, and it shouldn't be surprising that they tout these things as being nonpartisan. A candidate for Supreme Court justice must have been admitted to practice law for at least 7 years before assuming office. About 400 local courts, all kinds of stuff. A lot of times they handle shoplifting and um, possession cases, marijuana possession. So, how do you administer all this? Because it's a lot. The Judicial Council is the state level judicial agency charged with developing policies for administering and improving the courts. 24 representatives of the appellate and trial courts make up the council. The Chief Justice and presiding justice of the Supreme Court act as the chairperson and vice chairperson, respectively. Council also has the chief judge and another judge of the Court of Appeals, the presidents and presidents elect of the superior state, juvenile, probate, and magistrate court councils, and the 10 superior court district administrative judges. They do things like generate statistical information, provide publications, and they act as a liaison with judicial branch policymaking groups. Liaison is like someone that connects one person to another. So in this case, these policymaking groups would report to the AOC, and the AOC could relay that information to the rest of the judicial branch. They also coordinate the annual judicial branch appropriations requests and other fiscal services, basically asking for funding. Appropriations for judicial salaries and operating expenses at the appellate level come from state revenues. State and county finances share funding for the superior courts. Limited jurisdiction courts are funded solely by county governments. Continue and educate you guys. First, we'll get you um, on the court, and then we'll worry about continuing education. So, this is super cool. Well, that might be a bit strong, but it is cool. They have, um, and I actually grew up with a woman, I should say, who's now a Supreme Court justice in Georgia. It's pretty cool. Um, we can actually see oral arguments because they did it on a Zoom meeting. So, Medina versus the state. Let me see how much time we have left. All right. So first, we'll watch some of this on in a minute, but let's see here. So here's the case that we're going to be looking at. Man accused of shooting, killing squatter charged with murder. This is an Atlanta case. The man accused of shooting and killing a squatter Monday morning at his relative's DeKalb County home has been charged with murder. DeKalb County, basically, he was sent over to a relative's house and he went in and he found a trespasser. A squatter is just someone who's living in a house that doesn't belong to them. They just squat down. So Medina went in to check the property, and there was a squatter in there, and he killed him. And he was charged with murder. Man accused of killing Georgia squatter, charged with murder. He was convicted of murder, went through the various courts of appeals, and eventually it made it to the Supreme Court of Georgia. So we can actually see oral arguments. These are the lawyers, and these are the justices. So let's watch a little bit of this on our way out. Don't you freeze on me. Let's try this.
May it please the court, my name is Warren Hines and I represent the appellant Innovative Images. We appreciate the opportunity to appear remotely before the court. I do want to state
That's not what we want. This is what we want.
Yes, good morning to this honorable court. And first of all, I would also like to tell Justice Blackwell, thank you for your service to the court. I represent Terrence Medina, the appellant in this case. And Your Honor, this is a case, in which the Georgia Supreme Court can now instruct the trial judges what to do when you wade into those waters, those deep waters dealing with hung jury mistrials. This was a hard-fought homicide case in which at some point in time the jury announced that it had a unanimous verdict as to count one of the indictment, which was malice murder, but could not reach a unanimous verdict as to the other counts. And so at that point in time, things got a little confusing as to what should or should not happen. I provided the court with a little bit of a timeline chart as to what did happen according to the transcript. When that jury announced that they were not able to reach a verdict as to the other charges, basically the state at that point in time said, we're requesting a mistrial. Trial counsel also concurred at that time, we're requesting a mistrial. The trial judge should have at that moment declared that mistrial, but the trial judge did not. The trial judge had some concerns, as you see in the chart, about what would happen if he declared a mistrial and there was a unanimous verdict as to count one, which was the malice murder. The trial judge expressed those concerns about whether or not it would be proper, whether or not that verdict will stand. The court asked the lawyers for some additional argument. All of the lawyers at that time, the trial lawyers in the state, said, well, we didn't have any case law, on that issue. And the defense counsel basically stated, well, however, judge, I'll just leave it to your discretion about what to do on the count one malice murder. At that moment, the trial judge should have declared a mistrial. They did not. What happened if you look at page 406 of the trial transcript? The trial judge says, I have consulted with counsel in this case, and they have agreed that I should declare a mistrial. I am going to declare a mistrial. Whatever your verdict is, we do not know this. I will ask you to come back with a copy of the verdict form signed, indicating what your verdict is as to count one. That jury went back, came back into the court, and as you see it later in the transcript, the court addressed the foreperson as to whether or not a verdict had been reached, and the foreperson said correct. The court says, will you give that verdict form to the bailiff? And I will announce it in open court. And the court says the verdict form reads as to count one malice murder, we find the defendant not guilty. There is no resolution as to counts 2, 3, and 4, so I do hereby declare mistrial on all 4 counts. I think now we go back to that case that the Court of Appeals, we cited that case in our brief, the Archie case. The horse had gotten out of the barn by that time, and it was too late to close the door, or closing the door was a moot act at that point in time anyway. I think because of the sanctity of jury verdicts in this country, in this state, whether it's a guilty verdict or whether it's a not guilty verdict, there's a certain sanctity about that verdict. Once that verdict is published in open court by a court official, the clerk, or the...
That's so cool. Did you guys hear what he was saying? There's a sanctity about the court decision. That was very neat. You can go georgiasupreme.us and watch those if you're really bored, if you run out of content on Netflix. Okay, guys, have a great weekend. Talk to you on Monday. Special edition class on Monday.